Good morning, everyone. Thanks for joining us today. As Employment Counsel, Emily and I know firsthand how complex and nuanced the landscape of pregnancy leave and accommodation laws have become. Over the past few years, we've seen significant developments not only in state level requirements, but also in federal law with the Pregnant Workers Fairness Act, or the PWFA, and implementing EEOC regulations. So just put up our agenda here. Our goal for today is to help you navigate these various obligations, or at least help you to identify the right questions to ask when you're faced with complicated pregnancy leave and accommodation requests. We've got pretty limited time to cover a large amount of ground, so we'll start by briefly reviewing the key legal frameworks governing pregnancy leaves of absence, including FMLA, CIFRA, and California's Pregnancy Disability Leave, or PDL. And then for the majority of today's session, we'll dive into the PWFA, what it requires, how it differs from the prior laws, and what practical steps you might take to ensure compliance. We'll also walk through real world examples to help illustrate how these rules apply in practice. We'll share some suggested practices for updating policies, training managers, and generally responding to requests. Um, and thanks to those of you who already submitted some questions in advance. We've tried to incorporate the answers to those into our presentation today. For everyone else, if you can please save your questions for the end. We'll try to get through the material and then save at least the last 10 or 15 minutes for your questions. So with that, let's get started. So we'll start with the leave type that some of you may be most familiar with, leave under the Family Medical and Leave Act, or FMLA. Under the FMLA, eligible employees are entitled to up to 12 weeks of unpaid job protected leave each year for certain family and medical reasons, which does include pregnancy related health conditions and the birth or care of a child. To qualify, an employee must have worked for the employer for at least 12 months, logged 1,250 hours in the past year, and the employer itself must have 50 or more employees within a 75-mile radius. So this does not apply to everyone, but it does apply to most mid-sized large employers. While the leave itself is unpaid, a lot of employers do choose to provide compensation, though it's not required. Importantly, as we go through the next couple of leaves, FMLA leave can run concurrently with California's CIFRA and pregnancy disability leave. And it's also important to note that it applies to both parents, so not just the primary caregiver parent, but the secondary caregiver as well.
Continuing with pregnancy leaves, for those of you in California, the California Family Rights Act, or the CIFRA, also applies. It's very much like the FMLA that Jaya just covered. It provides for 12 weeks of unpaid protected leave each year for eligible employees. There's a 10-year and work hours component. The employee must have been employed for at least 12 months and worked at least 1,250 hours in the last year. The employer must also employ at least 5 employees for the CIFRA to apply. And again, like the FMLA, the employer can choose to have a policy that compensates these employees, though that policy is not required by law. CIFRA applies to the birth and care of a child, including those children birthed, adopted, and fostered. This aftercare is often called baby bonding. The statute encourages employees to provide 30 days notice ahead of leave. And the CIFRA, as Jaya just mentioned, can run concurrently with the FMLA, but it will run after any pregnancy disability leave or PDL, which Jaya will cover in the next slide. And of course, if there's more than one parent, the CIFRA applies to them equally.
So California's pregnancy disability leave offers up to 4 months. I think it's technically 17 and a third weeks of unpaid job protected leave for employees who are disabled by pregnancy, childbirth, or related medical conditions. This protection applies per pregnancy. Unlike FMLA and CIFRA, there is no tenure requirement to be eligible to take PDL. Employees are eligible from day one. The amount of leave, though, might be prorated based on hours worked. And this one only applies to the pregnant employee, not their partner or the secondary caregiver. PDL as Emily just mentioned, it can run concurrently with the FMLA, but it precedes CIFRA leave. So, what that practically means is that an employee could stack both leaves. So they could take their full pregnancy disability leave and then take the baby bonding leave under the CIFRA. As with the other leave laws that we just briefly mentioned, the statute does suggest 30 days notice, but flexibility really is key. Um, this is a requirement for all employers with five or more employees, so similar to CIFRA in that regard. And again, while compensation is not required, many employers do choose to provide some sort of paid benefits during this period. For example, to supplement disability or paid family leave pay. In California, employees who contribute to state disability insurance or SDI programs may be eligible for paid family leave, which provides partial wage replacement for up to 8 weeks when an employee takes time off to care for a new child. So a lot of employers, for that 8 week period, for example, might provide the difference. But again, this is not required under statute, so this is really an individualized decision for each employer.
We will dive into pregnancy accommodations now, based on the questions that we received before the presentation. It appears that most of you are really interested in learning about pregnancy accommodations, particularly as they relate to the Pregnant Workers Fairness Act or the PWFA. So we'll spend sort of the bulk of this time discussing these issues today, but so that we can, appreciate how the PWFA has really sort of change the legal landscape of how employers accommodate and engage in the interactive process with pregnant employees. We figure we should just start with sort of a legal overview of the pregnancy accommodations before the PWFA was enacted. So first, we have the Americans with Disabilities Act. This is a federal law that prohibits discrimination against qualified individuals with disabilities. It requires reasonable accommodation of those disabilities, which the ADA defines as a physical or mental impairment that substantially limits one or more major life activities. Next, we have the Pregnancy Discrimination Act. This is also a federal law and prohibits sex discrimination on the basis of pregnancy. And then finally, if you're a California lawyer, the Fair Employment and Housing Act, this prohibits discrimination based on sex, including pregnancy, disability or medical condition, and it also requires leave and reasonable accommodations for conditions related to pregnancy. And again, as a reminder, though, we're going to talk a lot about the PWFA today. The ADA, PDA, and FEHA still apply and should certainly be, top of mind when identifying reasonable accommodation for any pregnant employee.
So the PWFA was passed by Congress in 2023, and in June 2024, the EEOC regulations interpreting the PWFA took effect. In general, the PWFA requires employers with at least 15 employees, regardless of the industry, to accommodate an employee or applicant's known limitations related to or arising out of pregnancy, childbirth, or related conditions. Again, important to note there that it applies to qualified employees or applicants for employment. So although the ADA, PDA, and the FEHA laws that Emily just briefly recapped already required that employers provide accommodations and leaves for workers who are disabled by pregnancy, the PWFA's requirements are more stringent because they provide protection for limitations. So not just a disability. And a limitation is defined to be much broader than a disability. It includes things like morning sickness, lactation, contraception use. Um, and there was a whole list in the statute of conditions that the PWFA applies to. It applies to past pregnancy, so conditions that survive after the 40-week pregnancy is over. It applies to potential pregnancies, treatments, infertility treatments, including IVF. It can cover miscarriage treatments, stillbirth, having or choosing not to have an abortion, postpartum depression. So really, unlike the statutes that we discussed before, the PWFA is intended to apply very broadly and is not just looking at accommodations through the lens of a disability, but is really focused on identifying anything that might be a potential limitation arising out of not just pregnancy, but a pregnancy related condition. So the regulations have also confirmed that in practice or in terms of what they will enforce, the definition of a limitation is very broad. It can include a quote modest, minor, and/or episodic impediment or problem. The regulations have included some explicit examples of what's considered a limitation under the PWFA, including, things as minor as pain while standing. It can include things like lifting restrictions, time off for medical appointments, limiting exposure to hazardous chemicals, schedule modifications. Really, the regulations have made it clear that the law is intended for the definition of a limitation to be interpreted very broadly, covering really all types of limitation that are needed to maintain the employee's health or the health of a pregnancy. The EEOC regulations also include, as I just discussed, a list of conditions that fall within this definition that expand beyond just a pregnancy, including past pregnancy, potential pregnancy, post-pregnancy. Um, so this is really not limited to conditions related to a current pregnancy. So whereas before, employers might have been looking at the analysis in terms of a 40-week long pregnancy, the PWFA is really intended to encompass situations that could arise before, during, and after.
Perhaps the most difficult for employees related to the PWFA is the PWFA's requirement to temporarily excuse pregnant employees from performing the essential functions of the employee's position if it's due to a pregnancy limitation. This is a major shift away from other statutes before the PWFA, which had suggested no need to excuse essential functions of a position as a reasonable accommodation. But under the PWFA, an employer must accommodate a pregnant employee by excusing one or more essential job functions when it can be determined that the inability to perform the function is temporary, and that the function could be performed in the near future, for example, within 40 weeks of a typical pregnancy period. And also if the inability to perform the function can be reasonably accommodated, of course. And so again, we just highlight this because it's a major shift away from law that had otherwise suggested that excusal of an essential function was not required, but now under the PWFA, that limitation isn't granted. All that said, an employer need not excuse the essential functions of a position for a pregnant employee if providing the accommodation causes the employer an undue hardship. Guidance for, considerations of when assessing an undue hardship include the length of time that the employee is or will be unable to perform the essential function, whether the employee can actually be offered other work by the employer, what the nature of the essential function is, and the frequency at which that function is performed in the regular course of the employee's job, whether the employer has temporarily suspended the essential job functions for other employees, which is interesting, suggests that, consideration of what the employer has done in the past and their past practices is relevant to the inquiry. Whether other employees, temporary employees, or third parties can perform the function instead of the pregnant employee, or whether the essential function can be postponed or underperformed while the employee has the pregnancy limitation. Note that an undue hardship actually means significant difficulty or expense. And so this, together with, some of the points that we just went over, infers that the fact finder will probably be assessing the employer's size, their revenue, probably the diversity of potential job functions that employees can perform, and like I mentioned earlier, past accommodation decisions when assessing whether an employer should have provided reasonable accommodation. So something to keep in mind.
So the PWFA is also in the regulations identified specific types of accommodation that they will have expressly deemed reasonable under most circumstances. Some of these are surprising and maybe very confusing. Some of them are obvious. For example, carrying or drinking water in an employee's work area, that's kind of a more obvious one. Additional restroom breaks, seating for employees that typically stand. Telework, so this is one that the regulations have expressly included as an accommodation that in most situations is going to be reasonable. And I know based on the questions we got is kind of an area of concern for a lot of employers, and also additional breaks to eat and drink. So as Emily just mentioned, employers may still deny these accommodation requests if they can prove undue hardship, but that is likely going to be very difficult to prove. The standard is very tough, and frankly, given how new a lot of these regulations are, still very untested. So there is this carve out for undue hardship, but practically there haven't been that many proved examples where undue hardship has successfully been used as an argument to deny accommodations. Another kind of significant departure from accommodation laws in the past is that the PWFA actually limits the ability for employers to obtain supporting medical documentation. They have explained that it's only that employers can only ask for supporting medical documentation when it's reasonable under the circumstances. You know, this is, it seems, drawn in large part because it may be difficult for pregnant workers to obtain medical appointments and supporting documentation, particularly earlier in their pregnancies or on short notice. So this will be interpreted very narrowly, and the regulations have emphasized kind of throughout the enforcement manual that there are limited circumstances in which an employer can ask for documentation. For example, the regulations state that it is not reasonable to require documentation when both the limitation and the need for an accommodation are obvious. For example, when the pregnant workers request a different size uniform or safety gear. They also deem it unreasonable to require documentation when an employee asks to carry and drink water, take more frequent rest breaks, be permitted to sit at work, or asked to have their station move closer to the restroom, for example. Since these are all known limitations that are typically associated with pregnancy. The regulations also expressly identify some other conditions that are obvious and cannot be used as a basis alone to request documentation. Again, limitations commonly associated with pregnancy, such as morning sickness, fatigue, back pain, lifting restrictions, medical visits, and time to recover from childbirth. Lactation related accommodations similarly should not require supporting documentation. And it's really important here that employers are being cautious when they're making the determination that they really need supporting medical documentation because a request for documentation that is not reasonable under the circumstances could support a claim for PWFA interference or retaliation. Some situations where it could be reasonable to require documentation. An example is lifting restrictions, specifically to quantify what that restriction might be so that the employer can understand the specific weight limitations that have been imposed by the employee's physician. Um, but in those situations, when an employer determines that some sort of supporting medical documentation is required, the minimum documentation is typically going to be sufficient. So basically, a simple statement that the employee has a condition that meets the broad definition of a limitation and describing what work adjustment or change is needed. There's no need for a formal diagnosis. If necessary, it can also be reasonable to ask that the documentation include an estimate of the expected duration of the modification. This might come into play more when we're talking about post-pregnancy limitations. During a pregnancy, the regulations have made it pretty clear that, typically a 40-week long duration is reasonable. It does not need to be quantified. But when we're talking about post-pregnancy limitations and modifications, it may be reasonable to ask for a medical note supporting the duration of the limitation.
All right, so we've talked about the law a lot, and considering that you all are dealing with these issues on the ground, we thought it would be worthwhile to just walk through a few examples. And as Jaya mentioned in the beginning, we tried to cover some of your questions at least through these examples, but are definitely looking forward to hearing more about your questions after we go through these. So. The first one, as spoiled, is a telework example. So Blake is a software engineer who's just entered her second trimester of pregnancy. Blake works for a technology company that permits telework 2 days per week. Blake tells her manager that she cannot work in the office for the duration of the pregnancy, for example, 6 months, because her pregnancy has caused high blood pressure and traveling to work makes her anxious, exacerbating the high blood pressure condition. Um, for interactive purposes, if you could just use the Zoom hand raise function, if you think that the employer must accommodate Blake's request, that would be great. We'd also love to hear your comments in the chat if you feel so inclined. We'll give people a second to think and weigh in before we present our analysis. Okay. We could probably do a whole presentation on telework, and as we mentioned, we know a lot of you are interested in learning more about the work from home boundaries. So here's our analysis for what it's worth. Blake has a known limitation and has made the request for reasonable accommodation. Blake said that she needs to maintain her blood pressure, which is a condition related to, affected by, or arising out of her pregnancy. And Blake says that she needs to work from home to avoid exacerbating the condition. Blake has also communicated the information to the employer. Blake's qualified. She has to work from home, and the inability to work from the office is temporary, right? She suggests that maybe she could return in about 6 months, and Blake's need to work from home every day might be reasonably accommodated given that her employer already permits employees to work from home 2 times per week. So probable outcome here is the employee probably should permit work from home or some other reasonable accommodation absent an undue hardship. Um, we note that the qualified piece of the analysis could change if working from the office is an essential function and the limitation is permanent and not temporary. But as we're seeing now, and I'm sure you all are seeing as well, showing that in-office work is an essential function of an employee's position in 2025 can be quite difficult. A lot of employers are and have been assessing this issue well outside of the context of employees with pregnancy limitations. For example, it's important for employers to really be thinking about, whether it's just the employer's preference that employees come to work into the office, or if there's really something essential about that employee's in-office work. Of course, it's a very fact-specific inquiry, and so like anything else, it should really be assessed on a case-by-case basis. But overall, we anticipate this is a hot topic, so we thought we would mention it. And as we mentioned earlier, we of course welcome your questions or any specific questions about telework at the end.
I did see one comment on the chat about
Great.
whether it would be reasonable to request documentation in this situation. Um, I think the answer to that is a little bit complicated and it really depends. Emily had started to talk about, whether this job in particular really requires in-office presence as an essential function. If there is a good argument that that is true, I think there's a stronger argument to ask for documentation. But if it really is just a preference, the employer prefers for employees to work from the office a couple times a week, this might be one where it's not reasonable to ask for documentation. High blood pressure is a known limitation associated with pregnancy. Another, situation in which it would be reasonable to ask for documentation is if the limitation extends past kind of the projected just duration of the pregnancy here. For example, it extends into a post-pregnancy request for telework. At that point, it may be reasonable to request supporting medical documentation to define what the duration is and understand the limitation a little bit better. But for this situation in particular, during pregnancy, kind of a temporary request for a 6-month accommodation, barring a situation where working from the office really is an essential function, it may not be reasonable in this situation to ask for medical documentation. Okay, so another kind of real world example here. So in this situation, Taylor's position as a delivery driver involves lifting heavy packages that weigh more than 20 pounds. Upon returning from work after giving birth, Taylor tells her supervisor that she has a lifting restriction of 10 pounds due to cesarean delivery. The restriction is for 8 weeks. The employer does not have an established light duty program, but does have other administrative, for example, inventory positions that Taylor could perform. So again, in an effort to make this interactive, please use the Zoom hand raise function if you think that the employer must accommodate Taylor's request, and feel free to drop any comments in the chat. Okay, looks like pretty universally we're getting some hand raising, and that is exactly right. So going through the analysis here, known limitation and request for reasonable accommodation. Here, Taylor's need to avoid more than 10 pounds is a physical condition that is related to affected by or arising out of pregnancy, specifically here, her C-section delivery. Taylor needs an adjustment or change at work due to the limitation, and Taylor has communicated this information to the employer. So the first aspect of the analysis, she's fully satisfied. Whether she's qualified, so if modifications that would allow Taylor to continue to perform the essential functions of her position, such as suspending a lifting restriction, are not effective or cause an undue hardship, Taylor could still be qualified under the definition that requires, under the PWFA, a temporary suspension of essential functions. It's clear here that Taylor's inability to perform the essential function is temporary. The restriction is for 8 weeks. And the employer in this situation could suspend those essential functions that require her to lift, including by assigning her inventory duties. So the possible or likely outcome here is that the employer must accommodate Taylor by temporarily suspending the lifting function or by providing some other reasonable accommodation absent an undue hardship showing. This example really underscores a key takeaway. Employers must think creatively and flexibly when responding to accommodation requests, even if it means temporarily removing essential job functions. This is, as we discussed kind of when we were just talking about the law, a more significant departure from prior laws, which in a situation like this where lifting is an essential function, the employer may just have offered an 8-week leave of absence. But the PWFA has actually repeatedly said in the regulations that leave must be used as a last resort when responding to accommodation requests under the PWFA. So here, given the 8-week duration, it's a reasonable amount of time. The clear notice that this arises out of a pregnancy-related condition and the possible alternate work here, inventory duties, it is very probable that the employer would be required to accommodate.
More examples. We'll look at a request for schedule adjustment in this one. So Alex is a nurse who works the least popular morning shift beginning at 7 a.m. Alex tells their supervisor that they're having trouble coming to work on time because of their morning sickness, which generally occurs between 6:30 a.m. and 9 o'clock a.m. Alex requests to work the very popular mid-morning shift beginning at 10 a.m. Alex estimates that their morning sickness will become more manageable in the next month or two, but is not certain. Alex's supervisor has not noticed that Alex has been sick during work, and a review of Alex's time cards confirms that Alex has not come late to work once. Please use the Zoom hand raise function if you think that the employer must accommodate Alex's request. And again, welcome your comments in the chat if you have more complex or robust ideas. Sort of a trickier one. So here's our analysis. Alex has a no limitation and has made a request for a reasonable accommodation. Alex's morning sickness is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical condition. Alex says that they need a schedule adjustment due to the limitation, and it's definitely communicated the information and the needs of their employer. Alex is also qualified. Alex says that they need to work another shift until their morning sickness subsides. The morning sickness is temporary, even though Alex says that they're not certain when it will subside. The employer can assume that it will stop no later than Alex gives birth. And per the EOC guidance, that is temporary. And Alex's request to work after their morning sickness subsides might be reasonably accommodated by assigning Alex to the mid-morning or perhaps afternoon or evening shift, whatever the employer has. And so the probable outcome here is that the employer should grant the schedule revision or provide some other reasonable accommodation absent an undue hardship. There are a few kind of red herrings in here that we wanted to point out. The first is that it doesn't matter that the employer has not seen Alex become sick at work or actually be late to work, because the inquiry here is just really focused on whether it's related to a pregnancy limitation, and if there's a reasonable accommodation request that's been made. Is a second red herring here too is that of course in the qualified section, it doesn't matter how popular the shift is, right? More broadly, an employer's subjective belief about why the employee is requesting the accommodation isn't relevant under the PWFA, and of course isn't relevant under any other accommodation law. We note that, in this case, maybe the employer could have an undue hardship argument. If, for example, the employer has a significant difficulty assigning others to work the morning shift. But again, these arguments really haven't been tested yet by the agency or by the courts. And so, it's a very fact-specific inquiry, and the employer would want to assess everything on a case-by-case basis and really take all steps to reassign or otherwise accommodate Alex in this situation.
Okay, so one more example here, we're going to be talking about lactation breaks. So in this hypothetical, Dylan is a private finance professional who just resumed work following pregnancy-related leave. Dylan anticipates nursing for the first 3 months back to work. Dylan has asked Human Resources for two additional 30-minute lactation breaks throughout the day. So please use the Zoom hand raise function if you think that the employer must accommodate Dylan's request. Okay, so it looks like pretty unanimously here. We also got a number of hand raising. So here, going through the analysis again, Dylan's lactation is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. Dylan needs two additional breaks, and Dylan has communicated this information to their employer. So Dylan has satisfied the first aspect of this analysis. Qualified. Dylan has explained that she needs two extra breaks during the workday, and the nursing is temporary. It's just for a 3-month period. So in this situation, most likely Dylan is qualified. So here, the clear probable outcome is that the employer must grant the extra break accommodations or another reasonable accommodation absent an undue hardship finding. This is one where it's going to be quite difficult to make that undue hardship finding. I also saw a question in the chat here about requiring medical documentation. This is actually one of those examples in the PWFA where the regulations have expressly stated that it is likely not reasonable to ask for documentation for lactation related limitations, since that is a known limitation arising out of pregnancy or related condition. And I might have mentioned this already, but where it could become reasonable is if the duration extends past the 3-month period, or maybe even after a 6-month period. Or if the request was for more than just breaks. For example, kind of going back to our first example, if it was a request for telework based on lactation, there it might be reasonable to ask for medical documentation to really understand the limitation and the duration of the limitation. But for this specific hypothetical example, where the employee is just asking for two additional breaks during the workday and has explained that the nursing need is temporary, just for a duration of 3 months, the probable outcome is that the employer must grant that accommodation request without actually requiring further supporting medical documentation.
All right, a bit of advice. So, of course, if you're ever unsure about whether your company's policies conform with the legal requirements, we suggest that you reach out to your trusted outside counsel, and see what they think, and see if there are any opportunities for improvement. But in any case, a good first step is just to make sure that your company's policies have been updated since the PWFA to at least track some of those broader PWFA requirements. For example, ensuring that policies discuss pregnancy limitations, not just disabilities, and ensuring that those will be accommodated. Another really important thing is just to train your employees. Supervisors need to be able to pick up on these requests for accommodation related to pregnancy limitation, and they might not always be so hard to spot, or easy to spot rather. And so, you need to make sure that they understand the law, and that they're poised to handle these requests for accommodation. Folks working in human resources or accommodation specific departments too will need to be ready and able to review a lot of these requests and assess potential accommodations. So, they should also probably be aware of at least the accommodations that the EEOC has already expressly said might be reasonable. And they should also be able to appreciate the complexities and, when appropriate, the boundaries of the employer. So training is just really a big piece here that we wanted to emphasize. Since the PWFA, employers should also be carefully considering when they do and do not need to gather information to implement an accommodation. We've already seen at least a few questions in the chat about that, and so we understand that the lack of guidance there can be a little bit confusing. But really, post PWFA, employers should only be asking for documentation when the limitation is not obvious or already known. Next, of course, careful consideration about whether the employee can perform the essential functions of their position with or without a reasonable accommodation. And of course, this includes assessing whether the limitation is temporary, which, as we've covered at this point ad nauseum, during pregnancy could mean 40 weeks. So, that's important to just generally be aware of and start, kind of shifting your mindset a bit. And then, once an accommodation is identified and implemented, it's just important that somebody's sort of there to check in and monitor the accommodation and, work with the accommodated employee just to make sure things are going okay and that no modifications are needed.
So I know we've covered a lot, and we probably could have spent the full hour just talking about overlapping leaves. But we wanted to focus today on the PWFA because of how much of a shift this is to the pregnancy accommodation landscape. These regulations have really fundamentally shifted how employers must approach pregnancy-related accommodations. The definition of a limitation is interpreted very broadly. I know I've said that quite a few times now, but it covers not only pregnancy itself, but conditions before and after fertility treatments, lactation, and postpartum recovery. So employers really need to think carefully before deciding how to respond to an employee's accommodation request when it arises out of a pregnancy-related limitation. They also need to think carefully before requesting medical documentation. In many cases, under the PWFA, it's not reasonable or not permitted. Um, as Emily just said, training managers, HR, LOA teams is critical. Um, these individuals need to recognize accommodation requests even when they're informal and really respond promptly. When in doubt, it may make sense to err on the side of granting the accommodation, even as we discussed earlier, if it means temporarily removing essential job functions, unless the employer can clearly demonstrate undue hardship. And I know we've used that term a lot kind of throughout the presentation without defining it, and that's because it is at this point rather undefined. It's really kind of an untested area, just given how new these regulations are. And in most cases, you're going to want to consult pretty closely with your trusted outside counsel before deciding something really poses an undue hardship because the PWFA has made it so clear that in most situations, granting an accommodation for a pregnancy-related limitation is going to be reasonable and required. Also, important to remember that under the PWFA, leave for pregnancy-related limitations, which prior to the PWFA might have been a very regular accommodation offering, should now be a last resort. The law encourages employers to really exhaust all options, even when it means temporarily removing essential functions, to actually keep employers working when they've requested an accommodation or job modification for their pregnancy related limitations. So that is the end of our kind of official programming